Well, good afternoon, ladies and gentlemen. Welcome back to Property Pick and Mix 2021. I'm Nigel Clayton. I'm not Geraint Wheatley, you probably spotted. I'm just stepping in for him to introduce our penultimate session today. It's a really good one. It's a really useful, practical summary of where we're up to on possession proceedings, which I know it's been a really complicated saga over the last year or 18 months. I'm personally delighted to be introducing two brilliant young barristers, Nick Taylor and Ian Cooper. Nick had a chancery and commercial pupillage with us last year. He was made a tenant last year. And you may have seen him. He stepped in and gave us a paper last year at the Property Pick and Mix, just picking up on possession proceedings then at that stage of COVID. He's joined this year by our newest member of the Business and Property Group, Ian Cooper. And together they're going to give us what I think they've called a booster dose on possession proceedings and where we're up to now. I just add this, that it's an absolute delight for me to introduce Nick and Ian. If ever you've heard the expression about rising stars at the bar, these are two of them. It's a privilege, frankly, for me to be working with guys of this caliber. And if you don't believe me, just have a look at their CVs on the Chamber's website. Click on members and have a look. I think they are two of the names you're going to be hearing about quite a lot in the future. So with that, I'll hand over, I think, first to Ian, who will start off on possession during the pandemic. Over to you, Ian.
Well, without further ado, as Nigel mentioned, Nick spoke to you at the Property Pick and Mix last year about possession proceedings, and 12 months on, we're here to give you that much awaited booster dose and to let you know what the position is now with bringing possession proceedings. I have set out on this slide what we'll be talking about today. So I'll be talking you through part one, where in a break from tradition, barristers normally have 3 points to make. There are 4 things I'll be talking to you about. Firstly, the ending of the overall arrangements. Secondly, the ending of Practice Direction 55C. Thirdly, notice periods, which I know is a topic that we've all had to grapple with over the past 12 months. And then fourthly, I'll be talking to you briefly about enforcement. Nick will then go on in part 2 to talk to you about forfeiture. So turning first to the overall arrangements. Now, as many of you will know, this was a set of guidance that was introduced on the 17th of September last year by the Master of the Rolls. It wasn't given formal backing in the form of a practice direction. It was seen as informal guidance, but the underlying purpose of it was to assist the courts in the relisting and the hearing of possession proceedings following the stay. Now, the Master of the Rolls announced on the 3rd of November of this year, the new Master of the Rolls, Lord Justice Voss, that the overall arrangements came to an end on the 1st of November. And I've set out on this slide the key aspects of the Master of the Rolls' statement. As I've set out, and I believe the slides have been distributed, and there should in fact be a link in the notes comment to the slide, which will take you through to the statement from the Master of the Rolls. But what he says is that the overall arrangements document should no longer be viewed as governing or guiding court procedures, which are properly contained in rules and practice directions or listing policies, which are a matter for designated civil judges to decide in light of local conditions. Stepping back, what this means is, in theory, we will be going back to something akin to what we had before the overall arrangements came in and before the COVID-19 pandemic. Now, of course, that statement needs to be caveated. The government, or there are reports only today of the government announcing a plan B in light of recent developments with COVID. So it may well be the case that further guidance is issued in the near future. However, the position as currently stands is that the overall arrangements are no longer applicable and that policies will be dictated by the practice directions and by local court policies. You'll see on the slide, I've raised one question, which is the status of those cases that are already listed. For those of you that had to deal with the overall arrangements, you'll remember that there was a review hearing that was to be listed with at least 21 days notice. And there was then to be a substantive hearing, which would take place not less or not fewer than 28 days after the review hearing. Now, there will be cases that are going through procedures at the moment. They have been issued and have had directions laid down for those review hearings and those substantive hearings. The statement from the Master of the Rolls doesn't those cases. It doesn't provide for any kind of transitional period. The advice, I think, would be that given that those hearings will have been ordered within the context and within the scope of a court order, the advice would be to comply with that court order, proceed as before, unless and until you hear otherwise. It will be a matter for local courts as to whether or not they decide to relist review hearings and substantive hearings that they had already listed. What I think we can say about the ending of the overall arrangements is that there is going to be some increase in case management. It appears that the Master of the Rolls is envisaging a return to some extent to what we had before. We'll query whether we'll be returning to block listings in a manner that many of you will be familiar with, but it's clear that this is an area that is going to change. Now, the second thing that I said I would talk to you about was again something that's coming to an end, and that's the ending of Practice Direction 55C. Now, the overall arrangements came into force on the 17th of September last year. Practice Direction 55C followed shortly after, 3 days later, on the 20th of September last year. And you'll remember that the purpose of Practice Direction 55C was to lay down a mechanism for the reactivation of claims that had been previously stayed under Practice Direction, what was 51Z. It became Civil Procedure Rule 55.29, and then along came Practice Direction 55C, which was, as I say, targeted primarily at the reactivating of claims that had been stayed in the immediate aftermath of the breakout of the COVID-19 pandemic. And I've set out on this slide a procedural practice direction update that came into force on the 12th of November this year. And I'll explain the red text in a moment. Before I explain the red text, you'll see that at the end of paragraph 1.1, it provides that the interim period runs until the 30th of November 2021. And that was until the 12th of November, that was the state of play, that the Practice Direction 55C was running until the end of November. Now, at the October meeting of the pithily named Civil Procedure Rules Committee, there was a discussion around Practice Direction 55C, including a former member of King's Chambers, His Honour Judge Nigel Bird. And it was agreed by the members of the Rules Committee that Practice Direction 55C was to come to an end. And that has been brought into effect by this procedural rules update. So this is a second piece. This is a more formal rule. The overall arrangements were of an informal guidance. The practice direction is a second piece of the puzzle that it appears to be coming to an end, as we appear to be coming to the end of the COVID-19 pandemic, or at least appears to be the case until recently. So this practice direction update provides for amendments to Practice Direction 55C, and those amendments are what I've set out in red. And you'll see that what is now the case is that the practice direction, and I'm reading here from paragraph 1.8, continues to have effect after the 30th of November in relation to claims issued before the 1st of December. However, for claims issued after the 30th of November, they're addressed in paragraph 1.9. And it's clear that the practice direction will not continue to have effect aside from paragraphs 6.1 and 6.2. So to make this a bit easier to digest, I have got a slide which sets out in a table what this means. So what it means is that if the case has already been issued and it was issued before the 1st of December, continue to comply with Practice Direction 55C. For any cases that have been issued in the past week or so, and any cases that are issued moving forwards, the only aspect of Practice Direction 55C which continues to have effect are paragraph 6.1 and paragraph 6.2. Now, you may remember, you may not, that paragraph 6.1 and 6.2 are those provisions concerning the notice requirements. So landlords are required to to serve a notice on the defendant 14 days in advance of the hearing, and then also to bring along 2 copies of that notice to any possession hearing. And that notice sets out the knowledge that the landlord has as to the impact that coronavirus has had on the defendant and any of their dependents. There are also other requirements if you're concerned with a case involving a social landlord, and also there are slightly different requirements when you're dealing with the accelerated procedure under Part 2 of Part 55. So I would recommend that you have reference to paragraph 6.1 and 6.2 if you're dealing with either of those cases. But the main point is that for new cases, the only element of Practice Direction 55C that continues to have effect is this requirement to file a notice. And you'll also see that I've noted at the bottom of the slide that in the minutes to the October meeting, Lord Justice Males explains that the work that was conducted by a cross-industry review, it was essentially a review group, which had also produced a report that led to the ending of the overall arrangements, and as announced by the Master of the Rolls. There may be, off the back of their report, there may be further reforms in the pipeline, but no detail is given as to what those reforms may look like. So I've touched there on 2 aspects of the regulatory puzzle that no longer apply. What does, of course, continue to apply is, or there are notice periods to comply with. Now, I know you'll all be extremely grateful to hear that on the penultimate hearing of today's Pick and Mix, I don't intend to go through each and every one of these regulations that I've set out on the slide. What this slide is intending to do is to demonstrate that the regulatory framework, as we're all aware, has been an ever-changing one, and it has led many of us to spend long periods of time in dark rooms with cold towels over our heads, as is shown in the picture. And here we see the previous slide set out the regulations that were concerned with notice periods and forms, the forms to be used, and that was just in England, not in England and Wales. Here we see regulations concerning enforcement. It's clear that it's been an ever-changing situation over the past 12 months. What we're here today to do is to communicate what the state of play is today. So focusing first on the position in England, the relevant regulation to which one must have reference is that I've set out at the top of this slide. And that's the Amendment and Suspension Regulations 2021, Statutory Instrument 994, which is a number I know you'll all have seared across your minds. Now, what that regulation does is 3 primary things for the concerns of anyone who is bringing possession proceedings today. The first one, the first change that it brings into effect is that for all notices served after the 1st of October this year, the notice period reverts back to what it was prior to the COVID-19 pandemic. So focusing on the Housing Act 88 and Section 8 and Section 21, that means that for Section 21 notices in England, the notice period is 2 months. I've set out on the next slide, and you'll have this in the slides that are distributed by Katie. I've set out the notice periods for Section 8 reliance on the different grounds. I don't intend to go through those in detail. They're there simply for reference. So that's the first main change that's been brought into effect by Statutory Instrument 994. The second one is that there are new prescribed forms that have been introduced for use in England. They're published on the gov.uk website. And again, in the slides, I provided a link to where those forms are to be found for Section 8 and Section 21. You're concerned with Forms 3 and 6A. And then the third change that has been introduced by the amendment and suspension regulations is that the relevant period for Schedule 29, so the Coronavirus Act, which is where all of these changes are taken into effect, the relevant period has been extended in England until the 25th of March 2022. So that's until the 25th of March next year. So under the current regulatory position, the government retains the ability to change notice periods up until the 25th of March next year. So it may well be, depending on how things, it may well be, depending on how things develop, that this situation changes again. But as I say, in England, the current position is that notice periods are as they were before the COVID-19 pandemic. And this is the slide that I mentioned, talking through, setting out the different notice periods under Section 8 notices. We turn then to the position in Wales, where the Welsh government has taken a slightly different approach. Now, in Wales, the relevant regulatory document that one need have reference to is, again, that I've set out on the slides, and it's the extension of the period of protection from eviction number 3 Wales regulations. Now, the position in Wales is not as it is in England, where in England it's returned to pre-pandemic levels when we're thinking about notice periods. In Wales, there remain restrictions and there remain amendments to the usual notice periods. In the Welsh jurisdiction, it's likely to be the case that a notice period is now 6 months when we're thinking about Section 8 and Section 21. All Section 21 notices are 6 months, and all Section 8 notices are 6 months, with 3 specific exceptions that I've set out on the slide. I needn't talk through them. You have them there for reference. If a notice is served that doesn't rely exclusively on one of those 3 grounds, then your notice period will be 6 months. Now, something I should have mentioned in the English situation is that period of validity for a Section 21 notice, which has changed over time during the COVID pandemic, has gone back to its original 6-month period. So that's the period within which the Section 21 notice must be served. Those rules don't apply in Wales. So in Wales, the only date one's concerned with is the 6-month notice period, as I say, with the exception of those 3 grounds under Section 8. The other point to mention when thinking about the situation in Wales is that the relevant period, I said it ran until the 25th of March next year for the English regulations. For the Welsh regulations, it runs until the 31st of December this year. Given the proximity of that date, I think we can expect something in the coming weeks, either amending or extending the current position. The current regulations are, in fact, an extension of regulations that were made previously in Wales. So it may be the case that they're simply extended further. So before coming to enforcement, there are just a couple of top tips that I would be giving practitioners who are looking to bring new proceedings, or alternatively have got proceedings on foot already, but just want to check what the situation is. Of course, both Nick and I are here to answer those queries, and our emails are provided at the end of these slides. The other route I would recommend is the guidance that's been published online, both by the Department for Levelling Up Housing and Community and also by the Welsh Government. And I have again provided links in the slides to the 2 relevant websites where that guidance can be found. What's particularly helpful is that both websites, both the Welsh Government and the Department for Levelling Up, have produced within their guidance, they have set out in a tabular format the notice periods applicable under Section 21 and Section 8 at different periods of time over the COVID-19 pandemic. So that provides a very easy to review and very accessible way of checking what the notice periods were at different times if you have any queries as to the validity of a notice period that was served during the pandemic. And then turning finally to enforcement. Now, I'm sure lots of people on this meeting will be aware that the stay of enforcement that had been implemented both in England and in Wales has come to an end. It ended in England on the 31st of May this year, and it ended in Wales a month later on the 30th of June this year. So the position is that it is possible to go away and have any possession orders that you may have enforced. I say that with a slight caveat in that it is the case that there won't be bailiff enforcement if there are any reports that people at the premises or the property are self-isolating because of a positive COVID test, or if they're displaying COVID-19 symptoms. There's also a requirement which is mentioned in the technical guidance that I mentioned previously for a 14 days notice to be given before any enforcement takes place. The only other thing I need mention when talking about enforcement is you'll see that in Wales, apologies, not in Wales, in England, it has been reported by letting agent today back in November that HMCTS are intending to impose a stay on the enforcement of possession proceedings over the Christmas period. That report, again, I provided a link to, mentions that similar announcements are expected from the devolved administrations. A recent Google search, I hadn't found anything in relation to Wales, but I wouldn't be surprised if Wales follows suit. Now, that ends part one of this presentation. Before I do hand over to Nick, there are just 2 points I wanted to mention. One is I haven't put it on the slide, but for those that are interested, there is some very interesting Ministry of Justice data that was published in November about the possession procedure, looking at the statistics between June to September of this year and at the numbers of possession proceedings that have been brought. I didn't put the data up here. I was conscious that we did have the penultimate slot. There's an interest, there's lots, one can spend a lot of time looking at what's there. The take-home message is that when considering the number of cases issued, orders made, warrants and repossessions, the position between June and September of this year is significantly down on the position between June and September of 2019, so the year before the pandemic. The only other point is that with regards to times for bringing claims, there has been a significant increase in the time taken to take a claim from issue through to enforcement. Though the Ministry of Justice put this down to the stay, I do think we can expect to see delays moving forwards. That's the first point I mentioned. The second point, we don't have time to talk about it now, but in any talk in which possession is being discussed, I just thought I'd flag that for those who are interested, there was a recent Court of Appeal decision handed down on Friday about the test under CPR 55.8 as to whether or not there's a substantial defence to be raised by a defendant to possession proceedings. The Court of Appeal have ruled that test under CPR 55.8 is the same in substance as a summary judgment test, which is an important point for those to bear in mind moving forwards. And if anyone wants to take that up with me offline, then as I say, my email address is at the end of the slides. With that, I will now hand you over to Nick.
Thank you very much, Ian, and thank you also to Nigel for that very kind, probably far too kind introduction. I think Ian has covered off the current state of play from the residential perspective very comprehensively. In my half of this talk, probably a little bit less than half, I'm going to talk about the situation with landlords with business tenancies, which inevitably really is a discussion on the current position with forfeiture proceedings. So if just, yes, thank you, Ian. Ian is my assistant for this next half. So in this part, I'll cover forfeiture just by way of a recap, really, where we have been for the last year or so and where we are now. In parts 2 and 3, I'll also touch briefly on other routes that landlords have tried, in particular to force the issue of non-payment of rent, just because I think they are quite interesting. And I'll also discuss the impact that the new, fairly hot off the press, commercial rent coronavirus bill has on forfeiture proceedings. And finally, I will look ahead in a somewhat future-gazing slide as to the hints and whiffs of future developments in the possession world. That largely will relate to residential possession. So even if you have no interest at all in business tenancies, it is a carrot I've dangled to hopefully stop you from tuning out now. But before kicking off, and because it is nearly Christmas, I do have a quiz for all of you. I'm afraid there is only one question, and that question is, as you can see on the slide, what do all of these dates have in common? And if you could please put your answers in the chat box. I should say that in the context of this talk, there is only one correct answer, but obviously I can't rule out another connection between the dates, which I'm not aware of. I'll give you all a few moments to furiously rack your brains and put something in the chat box. If we don't get any answers in the next few seconds, I will reveal the answer. It's a flurry of correct answers. I think Daniel Flowers just nips Daniel Blake to the post there. Peter Day in Jeremy Paxman style, I'm afraid I'm not sure I would give you that for specificity, but I think you're all clearly along the right lines, Simon, as well. Yes, the answer is that these are all dates upon which the relevant period, as defined in Section 82, subsection 12 of the Coronavirus Act 2020, had been slated to end, but which have been further extended. Now, of course, we can see that the first 6 have come and gone. We'll wait to see what happens with the 25th of March 2022, but for reasons I'll come on to, I suspect that probably will be the final date for that list. Daniel, I'm afraid to say there is no prize for the correct answer other than the glory. But obviously, everyone, please do feel free to use that question if at any point and there is a lull in the conversation at any social gatherings over the next few weeks. Certainly my experience, it's gone down very well. So since the start of the pandemic, in the context of business tenancies, they've really been in two broad camps. If you're a landlord with a business tenancy and the tenant default that you have wished to rely upon to found your forfeiture proceedings has been anything other than non-payment of rent, it has largely been business as usual. So provided that the usual criteria is satisfied, so the lease contains a forfeiture clause, there's been service of a Section 146 notice, no remedy of the default and no waiver of forfeiture, a landlord has been able to forfeit a lease in the usual way, at least in principle. Perhaps does ignore for now and put to one side any impact the pandemic may have had on tenants seeking relief from forfeiture as to the reasons for non-compliance with covenants and actually whether or not the time or reasonable period for remedying any breach has also been impacted by the pandemic. But in broad terms, landlords have been able to forfeit. The problem, as no doubt you're all acutely aware, has been where the tenant default has been non-payment of rent. And as you can see from the slide, in that case, it really just has been a case of do not pass go. it's also, as you've seen from the quiz question, a case of having one date marked in your diary for when possible forfeiture proceedings may be issued and served, getting close to that date and then crossing that date out and putting a new one in as the deadline continues to be extended. So section 82(1) of the Coronavirus Act, as you can see from the slide, has been the key bar and has really simply had the effect of blocking forfeiture proceedings for non-payment of rent or other sums due under a tenancy. The potential quid pro quo, although I'm sure landlords won't put it like that, is that by subsection 2, it states that landlords will not have waived their rights of re-entry or forfeiture for non-payment of rent unless an express waiver has been given in writing. Now, practically, that may have made things a little easier for landlords, but I stress the limits of that have not, as far as I'm aware, been tested by the courts, and I'm not sure how they could have been at this point. So certainly, in certain instances, I've still advised quite a cautious approach when it comes to possible waiver, just because it's probably not something which you wish to be relying on unless you really have to. So just moving on to the next slide as well, just to touch briefly, I think, on other means by which landlords have, if not perhaps gained possession or regained possession of their premises, have sought to at least recover rent arrears. Well, firstly, presenting a winding up petition on the basis of the tenant's insolvency by way of non-payment of rent, as is no doubt well known by this stage, the Corporate Insolvency and Governance Act 2020 and the inbuilt coronavirus test has made this an almost insurmountable uphill struggle for landlords, as the debtor company, especially where they are a tenant with a business tenancy, could almost always demonstrate a financial effect. And it would be very difficult, which is the first limb of the coronavirus test, and it would be very difficult for a landlord to prove that the tenant would have been unable to pay their rent irrespective of the pandemic, which is the second limb of the test. Normally, it was quite the contrary, and it was usually in the tenant's gift to prove that. I'm certainly not aware of any successful petitions brought against tenants under this basis, which have survived the coronavirus test. The second thing mentioned on this slide is what I probably describe as ordinary debt claims for unpaid rents. And for those who attended, Geraint's talk has comprehensively, and I would suggest authoritatively, really covered this in much more detail. But those will know who attended that talk, or generally, those sorts of claims have been somewhat more successful. That may be something of a Pyrrhic victory in some of those cases, given the new bill. And I'm aware that certain of those cases are subject to appeal, and it will be interesting to see what happens to the tenants' arguments within the Court of Appeal. But certainly, over the last year or so, tenants have struggled to resist at least normal debt claims for unpaid rent. So what I want to talk about now is where we are going. So again, going back to the quiz question, until the 25th of March 2022, from a forfeiture perspective, we are where we are. That is the relevant period to that date at the moment, and forfeiture proceedings for non-payment of rent still cannot be brought. But the good reason to think that my quiz question may not have another date added it to next year's Christmas quiz is the much anticipated commercial rent coronavirus bill, which has been published and is at least due to be enacted by the 25th of March 2022. It may be sooner, it may be later, but that's certainly the intended date. I stress that the bill is just that. It potentially will change. That said, the intention of the bill, I think, is pretty clear now. So if you spot a clever loophole in the drafting, I would suggest it is liable to be perhaps sealed off by the time of enactment, but we will see. So Geraint's talk has covered in far more detail the bill in general terms, and in particular its impact on rent arrears claims generally, and the proposed arbitration scheme. What I want to pick up on briefly is the impact on forfeiture. And apologies, because there is some overlap with Geraint's talk, but I'm aware not everyone will have seen that talk. And I think certainly from my reading of the bill, it's not the easiest piece of legislation to read, and it perhaps having it repeated there's no harm in that. There is a very important definition within the bill, which you can see on the slide here at the third bullet point, and that is the definition of a protected rent debt, which is defined in section 3. It is one of those definitions that I think is worth reading a few times, probably with a cold towel and perhaps a cold beer to hand. But in very broad terms, for the purpose of the bill, the way I would try and phrase and think about it is that a protected rent debt is a rent or other sum which is due under a business tenancy where the tenancy was adversely affected by coronavirus and the rent is attributable to a period of occupation for what's described as the protected period applying to the tenancy. So I'm afraid that is almost about as simply as I can put the definition, but it's not really the end of the definition, because the phrase adversely affected by coronavirus has its own definition within the bill. And you can see here again from the slide that in essence, it means that the premises were required to close in full or in part due to government restrictions. There are then further caveats and exceptions, but that is the essence of it. And that defines what, in much of the literature and commentary and guidance published about the bill and the proposed arbitration, is termed ring-fenced rental arrears. The language is all a bit numbing, frankly, but the Code of Practice for Commercial Property, which was updated and published alongside the bill on the 9th of November 2021, is actually quite helpful. And if you could take one thing away from this talk, it could well be the link which you can see on the slide, which takes you to the code. It actually takes you to the annex to the code, which contains timelines, which I'll come on to in a moment. But if certainly that link will take you to the code, and I'd suggest that the code is actually quite helpful in that it explains in somewhat clearer and plainer English the purpose of the bill, what is covered and what is not covered, and gives some helpful examples. So for the purposes of possession and forfeiture for a business tenancy, if I could go so far as to describe it as the good news about the bill, is that once the bill is enacted and the relevant period comes to an end, certain forfeiture proceedings for non-payment of rent can be issued. So, for example, forfeiture for any rent arrears incurred prior to March 2020, so that's before the pandemic, rental arrears incurred from the end of the ring-fenced period onwards, and also even if the tenancy or the rent falls out with the scope of the bill, which will be rare, but there are certain situations which will. So it's not always black and white. As to the ring-fence period itself, well, I think this is actually where the interest comes in to some extent, and it largely depends on the business and the industry. And there are a couple of helpful timelines in the annex to the code, and that link will take you to them. And I've just taken one for this slide. So focusing on England, which is the darker blue lines, you can see from the timeline at the bottom and where the dark blue lines run to that the vast majority of businesses had restrictions lifted on the 18th of July 2021, the so-called Freedom Day, which I'm sure we all fondly remember, especially given the news today. But actually looking at non-essential retail, for example, or perhaps even if anyone is trying to forfeit a lease of a garden centre, it might happen. It's actually a much shorter period for which any rental arrears would be ring-fenced. So if you do have protected rent debt, then moving on to the next slide, there is a moratorium on forfeiture proceedings for 6 months from the date of enactment of the bill, so probably to late September 2022, but we'll see when it's enacted. Or if the rent debt is referred to the arbitration process described in more detail in the bill and Geraint's talk, the date on which the arbitration concludes, which means really when an appeal is either determined or the last date for bringing an appeal, which passes without an appeal being brought. So what I think is the key takeaway from the bill, from the forfeiture angle, is that this is not just another extension of the relevant periods. It all now depends on whether your rental arrears fall to be considered as a protected rent debt, and if the rental arrears actually relate to a period for which restrictions had been lifted by reference to those timelines, which I think are quite helpful, then after the 25th of March 2022, you may be able to put forfeiture proceedings on foot. So it is, I think, one of those things which is worth looking at now to see whether or not there's any rental arrears which may fall outside the scope of what's described as the ring-fence rental arrears. That may be enough to get there. Just to touch briefly as well on the impact of the bill on the other roads, which I discussed earlier. Essentially, ordinary debt claims issued on or after the 10th of November 2021 can be stayed by application of either party pending a referral of the debts to arbitration. Now, interestingly, I think quite strikingly from a legislative power point of view, even if you obtain a judgment in that time, that judgment debt itself can be referred to arbitration and, pending the outcome of the arbitration, potentially modified and even potentially diminished or written off. Winding up petitions, well, up to the enactment of the bill, the relevant legislation now is the new Schedule 10 of the Corporate Insolvency and Governance Act 2020. And for a business tenancy, you cannot present a winding up petition unless, in effect, the rent is unpaid, but not by reason of a financial effect of coronavirus. So that's retaining something of the language of the old coronavirus test. And it's going to be a remarkably high hurdle to surmount. And certainly, I think, very unlikely that any such debts do still exist. Once the bill is enacted, there will then be, in addition to the moratorium on forfeiture proceedings for ring-fence rent debts, there'll also be a moratorium on most insolvency procedures, and certainly a complete inability to present a winding up petition in respect of the protected rent debt. So really just wrapping up this aspect, until the 25th of March 2022, or the enactment of the bill, possession for business tenancies still depends entirely on the nature of the default. Thereafter, it will all depend on whether or not the rental arrears can be classified as a protected rent debt or not. It's not always not the easiest of definitions to get your head around. It's perhaps a little bit more intuitive than appears at first glance, but certainly myself or Ian or any other member of the King's business and property team would clearly be very happy to advise on that. And it may be something that's worth looking at even as the date for enactment approaches. So very briefly, on the next slide, I really want to just touch on two things, really just to lay a marker for potential future developments and perhaps for Ian and I to stake an early claim for next year's talk topic. That said, actually, I'm very grateful to Nigel for pointing at least me in the direction of the possession reform project, because it is quite a newly announced thing. At the moment, there are not many details of this possession reform project. We know that it's a project which is due to commence in 2022, and it has the stated aim of, I quote, automating and streamlining the process of possession proceedings from start to finish. It was certainly mooted on the 23rd of November 2021 when HMCTS published a note about this possession reform project. And it follows really the workings of a judicial working group, which is to develop guidance and products on arrangements for possession proceedings now that the stay has been lifted. It's difficult to know to what extent this has been driven by the pandemic and will be linked to the changes that we've seen, in which to a large extent Ian has discussed, or really to what extent it was something that was always coming down the road anyway. It will certainly remains to be seen what will happen to that, but it's likely, I think, to tie into the rental reform white paper, which, although was promised in autumn of this year, At the Tory party conference, it was pushed back to 2022. It appears that the white paper is likely to cover the potential abolition of Section 21, grounds for possession under the Housing Act, reform of Section 8, mandatory forms of mandatory redress for landlord, the merits or otherwise of a landlord register, lifetime deposits and enforcement procedures. We don't really know when, what, or where it's going, but it looks like the changes which might be proposed could be the most significant changes to possession that we've seen in quite a few years. So it certainly is a case of watch this space, and maybe this time next year we will have more to talk about in that regard. So really that concludes my section on business tenancies. I hope it's of some use just to provide you with the current state of play and where we're going. But if anyone has any questions for either me or Ian, please do feel free to put them in the Q&A. I'm conscious I've gone slightly over time, so I think the next talk starts at 5. If we do have any time for questions, Nigel will let me know. Otherwise, you have our emails, and please do feel free to get in touch. Otherwise, just remains me to say thank you very much for coming along.
Wow, I've got to say, chaps, I don't know whether we as a department volunteered you to give that talk or whether you volunteered to do it yourself, but I'm not sure we've got many other people as competent as you to cover all that detail. I think many of the practitioners watching this will be just scratching their heads at how complicated these possession proceedings and forfeiture proceedings have become. And I think my practical advice, and particularly with your talk, is to probably print off these slides and have the detail at hand if you need to refer to them. I know one of the questions that popped up on the chat earlier, one of the points was that some of the links we're being given don't have all the links that you've provided online. I think that's now been corrected. We now have a link to the PowerPoint online, but I just point out to everyone that we are post-seminar going to send out a full post-webinar pack with all the documents and all the links. But as Nick quite rightly said there, if you have any specific queries about this particular content, do please feel free to email either Nick or Ian. Just on a personal point, insofar as you're engaged in mortgage possession proceedings, again, that's become hugely complicated recently. Have a look at www.legalmortgage.co.uk. There is a separate page called COVID-19 with all the links to the stuff on procedure there, including the recent notice about coming to an end of Practice Direction 55C and the overall arrangements. And finally, incidentally, I noticed that I think it was Ian mentioned the case on CPR 55.8, the test to be applied at possession proceedings at case management stage. The case is actually Global 100 Limited against La Leva. It's a 3rd of December decision, a Court of Appeal, an appeal from His Honour Judge Luber QC, who sits in the black hole that is the Central London County Court. Successful appeal. I think Jan Luber seems to do his own thing still these days, but I'll be reporting on that in the December update on legal mortgage. But again, chaps, wow, I take my hat off to you. You've covered an immense amount of detail there, very impressively indeed. That's it from Nick and Ian. We're just coming up to, I think, 10 to 5. We're going to close this session now, but of course, please don't miss our final speaker, Matthew Hall. He's a brilliant speaker. He's hugely entertaining, and he's got a cracker of a topic about what goes on underneath the ground. I haven't heard what he's going to talk about, but it's bound to be sort of riveting. So I bill him up straight away. But for now, chaps, thanks very much indeed for joining us, and hopefully see you at 5 o'clock.